Hello, my name is Peggy Nicholson, and I am the supervising attorney in the Duke Children's Law Clinic. On April 17th, 2020, the Children's Law Clinic filed an amicus brief in the U.S. Supreme Court asking the court to grant certiorari in Bruno v. Northside Independent School District, a case raising important special education issues that impact thousands of students with disabilities across the country. The clinic was joined in its brief by several national and state-based organizations that also advocate for students with disabilities. I'm joined today by Zack Kaplan, a law student in the Children's Law Clinic, who helped draft the brief, as well as by Professor Jane Wettach, who served as counsel of record and primary supervisor for the brief. Welcome. Professor Wettach, I wanted to start with you. Can you share more about the purpose of an amicus brief and why you thought it was important for the clinic to submit one in this case?
Sure. So an amicus brief, otherwise known as a friend of the court brief, is a supporting brief. It's filed by parties who are not the main parties in the case. Organizations or individuals that have an opportunity to share with the court some different perspectives that were not made available by the main parties, or to signal to the court the importance of a case. So this case was, as you said, Bruno v. Northside, was a case that raised an issue about the interpretation of a provision of the federal special education law, and it affects children all over the country. This one in particular raised the issue of what is known as comparable services protection. And that's a protection that comes into play when children move from one school district to another, which is, of course, millions of children every year who move. And the protection is that the new school district is required to provide immediately upon enrollment services that are comparable to the ones that the child was getting in the previous school district. So because this is of national importance and it connects directly with the main work that the Children's Law Clinic does, which is protecting and enforcing the federal rights for the children who we represent, we thought it was important to get involved.
And why is the comparable services provision an important federal protection for students with disabilities?
Yeah, so to Professor Wettach's point, it's really important that when these students are moving, that their special education plans from their previous schools are continued during this interim period when they move to a new school, while the new school has an opportunity, if they want to or need to assess the students' needs and then provide a new plan if necessary. This is especially important for students who are highly mobile. And so the student in this case was in a military family, and so is likely to move 2, 3, 4, up to 5 or 6 times even during his K through 12 career. It's also really important for students who have non-voluntary moves, such as students who are in the homeless a homeless population or in the foster care system, or just students whose families are living in poverty and are more inclined to move frequently. And so the purpose of the provision is to provide that continuity of care so that their special education services are maybe one out of very few things that can continue throughout this sometimes rocky transition.
Obviously, the U.S. Supreme Court only takes a relative few cases each term. Why do you feel the Supreme Court should take up this case?
Yeah, that's a great question. Again, to Professor Wettach's point, I think that this is a case that is highly impactful for really vulnerable students. So not only are we already, as a baseline, talking about students with disabilities who are particularly vulnerable, but also students with disabilities who are highly mobile. Again, whether that be because they're in a military family or something else, that means that these students are coming into contact or coming into the sort of purview of the comparable services provision again and again and again. And the reason why this case came up in the first place and why we signed on as amicus brief for our amicus brief is because courts have not across the country, from the administrative judge level all the way up to the circuit court and district court level, have not consistently interpreted and enforced this provision with its constitutional purpose of providing that continuity of care. So the Supreme Court obviously is in an extremely unique position to take a broader look at the different ways in which different courts and hearing officers have interpreted, or in some cases misinterpreted, the provision to the detriment of these highly vulnerable students, and sort of correct the course so that it's more aligned with the constitutional purpose.
So we might talk a little bit about the history of the case. Should I start that over? Because I talked over you. I'm sorry. A little bit about the history of the case. This was a case that was originally litigated in Texas and went through 3 appeals up to the Fifth Circuit Court of Appeals. And when it was at the Fifth Circuit Court of Appeals, the law firm representing the parents reached out to the Children's Law Clinic and asked for our support on an amicus brief in the Fifth Circuit. So last year, 2 law students in the Children's Law Clinic had the opportunity to write an amicus brief in the Fifth Circuit Court of Appeals. Regrettably, the case was unsuccessful in the Fifth Circuit, and so the lawyers representing the child and his parents decided to ask the Supreme Court to look at the case, to take it up through certiorari, as you said, and then reached out to the clinic again to help them support their case. And we were able to bring in 5 other national or statewide organizations that, like the Children's Law Clinic, support and advocate for children with disabilities under this federal special education law.
Zack, as a second-year law student, I'm interested to know what you learned during the process of drafting and filing an amicus brief with the Supreme Court.
Yeah, it was an incredible experience, and one of the many reasons why I encourage other students to participate in clinics, because it was not just an opportunity to engage in some real advocacy work, but immediately, halfway through my second year of law school, to jump into a project that was even more importantly than the fact that it was going to the Supreme Court, that it was speaking to an issue with such importance and such a broad impact on students with disabilities. So being able to jump right into that was an amazing opportunity. In terms of something or anything that was surprising to me, I mean, I knew, of course, that any Supreme Court litigation has a lot of hoops to jump through and procedural requirements. I was maybe surprised about how many of those there were and how specific a lot of those requirements were. Anything from the word count to the font to the margins on the page. They really have their style, and they like to keep it that way. And for us litigants who are petitioning the court, we just follow those rules. I think even more so than that, though, I was really happily surprised by the process by which we sort of crafted the brief with other parties involved. So as you mentioned, Peggy, there were a number of other education and special education focused groups, whether that be law firms or nonprofits or other clinics that were interested in signing on to the brief with us. And because of that, we were able to have communication and correspondence with those other attorneys all across the country in ways that really informed the nature of the brief itself. So they weren't just signing their names onto the bottom of it, but they really helped craft the strategy and the form that the brief ended up taking. And so being a part of that really nationwide collaboration with these groups that are all aligned on the same mission for students with disabilities was really rewarding.
Professor Wettach, I know this is not your first amicus brief or even your first time in front of the Supreme Court, but I'm wondering how the process was different given the COVID-19 pandemic and the switch to remote learning.
Right. So fortunately, we were pretty far along in crafting the brief as a team before we had to go remote. So we had a pattern of meeting weekly with the 4 of us, you and the 2 law students and me meeting to review our strategy, talk through the drafts that the students had produced during the week, and think through how they should relate, the different sections should relate to one another. So we were pretty far along when we had to go remote. So when we had our virtual meetings, I feel like we had a good solid foundation of working together and could continue to share things through email. Unlike other courts, the Supreme Court did not extend the deadline. And so we were working with our original deadline and were able to meet that deadline. One thing that was interesting is that the day before our brief was to be filed, the company that we worked with, who was helping us to format and print it, sent an email saying, well, normally the Supreme Court requires 40 printed copies of any brief that's submitted to the court, but because of COVID-19, all we have to do is submit one electronic copy. So that actually ended up saving some time and presumably some money.
Yeah. One last question for you, Zack. How do you think that this experience in the clinic has helped prepare you for your future legal career?
One thing that I really appreciated about the process was writing a document as a team, and of course a really important document. I had obviously done a lot of legal research and analysis and writing throughout my 2 years in law school, but this was really the first time that I was engaging in such important research and writing as one part of a larger team. And so, you know, like everybody, I have my own sort of habits and styles and particularities when it comes to the way that I research and the way that I write, that all sort of needed to be melded together with everybody else. Because it wasn't even just that we were working together and then one person would write the brief itself. It was that we were each writing different sections of a brief that needed to piece together into a broader and important message. So I think that skill of drafting the brief with other people was really, really useful, and something that, you know, won't be the last time that I do that in my legal career. And I think maybe even broader than that, the work that we were able to do as a team in our meetings regarding crafting really our theme of the case, or why this case was so important, was something that really taught me about taking a step back from the specific facts of this litigation and this client and this student in particular, and really made me consider what is the broader importance of this brief and of this case. And I think being an amicus brief as opposed to a principal party in the case sort of allows you to do that more easily. But it taught me that even when you are advocating for the principal party in the case and talking about specific facts, it's still important to consider the broader context and the broader impact, especially when you're looking at a court like the US Supreme Court.
So I'll add that the students really brought so much to the table. They were very interested in learning about the issue and learning how to be persuasive and learning how to write in a powerful way, and they worked really hard on it, and I'm very proud of our final product.
Yes. Well, thank you both so much. Any final reflections before we go?
Nothing other than the fact that it was a wonderful experience and a pleasure working under the supervision of both of you, and again, encouraging other students to participate in clinics if you get the opportunity to, because you never know when you're going to be writing for the Supreme Court.
Right. Well, thank you both so much.